Hi there, Jessica from Leverage Legal Group. Let's clear up one of the biggest myths I hear from founders and business owners all the time. I can use this. This is fair use, right? Well, maybe, but probably not the way you think. The truth is, fair use when it comes to copyright is one of the most misunderstood concepts. So today I'm going to explain what fair use actually means and how it applies to your business, if it applies to your business, and how to protect your own creative work, and also how to make sure you're not infringing on somebody else's. Fair use does not equal free use. So you have to understand these rules before you share things. So let's start with the basics. Fair use is a legal exception to copyright protection. It allows limited use of copyrighted material without permission, but only in very specific circumstances. So it's designed to promote things like education, commentary, criticism, parody. It's not intended to make it easier for businesses to market their products or services using somebody else's content. Fair use doesn't mean as long as I give credit to the original creator, and it does not mean as long as I'm not selling that thing, right? Those are common misconceptions. The law doesn't care if you give credit. That is not a protection against a claim of copyright infringement. What it cares about is the how and the why you're using the work. All right, so let's talk about what are called the four factors of fair use. Courts look at these four factors to decide if something qualifies as fair use. So let's go through them in plain English. The first factor is the purpose and character of your use. So are you adding something new and transforming that existing copyrighted item, or are you just republishing somebody else's work? So educational, critical, or parody uses are more likely to be fair use. Commercial uses like ads, websites, marketing content are less likely to qualify. So even if you're doing a comparison of your product with somebody else's, that is a commercial use. That does not fall under critical use. And so that's not going to, most likely that won't qualify as fair use. So factor one is the purpose and character of the use. Is it transformative, meaning did you change it significantly from that original content, or is it commercial? The second factor looks at the nature of the original work. So if the original work is highly creative, like music, art, some type of video, fair use is going to be less likely to apply. If it's factual information or informational, courts may be more lenient. The third factor is the amount and substantiality of what's used. So how much of the work did you use? The less you use, the safer you are. But even a small clip or quote can be infringing if it's the heart of the work. And so focus on if you're going to use somebody else's work, you need to use as little of it as possible. And you certainly don't want it to be what might be considered the heart of that work. And the fourth factor is the effect on the market for the original work. So if your use competes with or reduces the value of the original creator's work, that's a strike against a finding of fair use. So does it hurt the original copyright owner's market for their item, their original content? And that's important to keep in mind. And this is an issue that comes up with AI a lot, because people are arguing that the outputs couldn't possibly be infringement. It's all fair use because it's different than, how could you possibly have something that when the whole training set for AI is this big soup of data, the outputs have to be something new. But the reality is they're not. And a lot of the outputs that come out from AI prompts are very, very similar to original works. So you can never assume that just because it came out of an AI output that it's fair use and you can use it. There's actually quite a few lawsuits pending on this issue right now, including Disney just sued Midjourney for copyright infringement for that very reason. Those are the four factors. No single factor is going to decide this. Courts generally weigh them together. But the takeaway is this: if your business is using somebody else's copyrighted content for commercial gain, so again, it's not that you're selling their item, you may be using it to promote one of your products or services. That is commercial gain. In that instance, fair use is rarely going to be a defense that you can use for copyright infringement. So let's talk about common fair use mistakes that founders make. Here's one I see founders and business owners get tripped up on all the time. So mistake number one, using images, memes, or videos from Google or from social media because everyone else does it. It doesn't matter how many times it's been done. That's not fair use. It's infringement. And just because other people are doing it is not going to protect you from an infringement claim. Mistake number two, using copyrighted music in promotional videos or reels. Again, the key is promotional videos or reels. Even a few seconds of a popular song can lead to a takedown and/or fines. Number three, using competitors' content for education or inspiration. Unless you're commenting, analyzing, or transforming it, it is not fair use, and it never will be, particularly because you have a commercial motive. Mistake number four, believing that AI-generated remixes or mashups automatically qualify as fair use. They don't, and they can actually multiply your liability if the output incorporated copyrighted material from multiple copyright owners. Finding it online, using just a clip, giving credit, taking it from AI, those things are not going to protect you. Let's talk about what you have to do. You have to get permission or use licensed or ideally your own original work. That's how you protect yourself. So let's talk about how to protect your own content. Let's flip it around. What if you're the one creating the original content? You have rights, and fair use can sometimes affect your ability to enforce them. So let's talk about that. How do you protect yourself from somebody using fair use and using your materials? Well, number one, the most important thing is you need to register your copyrights. That's what gives you the right to stop others from copying or repurposing your work and to collect damages if they do. Now, I will say in the US, copyright is automatic. So the minute you create something, you have a copyright in it, as long as you created it and it's original. But if you don't register your copyright, you don't have the remedies you need to enforce your rights. So that's the difference. Registering your copyrights is what's going to give you the ability to get an injunction to stop other people from using your materials and to get money damages and potentially get your own attorney's fees and costs reimbursed from the infringer for having to have to go after them to enforce your rights. Number two, use clear copyright notices. So add the little C with the circle, the copyright symbol, and the year that you created the item and your business name, assuming it's your business that owns the copyright, with the sentence, all rights reserved. Put that on your website, put that on your courses, put that on your materials. It signals that you take ownership seriously, and it will be a deterrent for most people to not use your materials without permission. And if they do, the fact that you had that notice up gives you the ability to establish an intentional infringement claim because they should have known. They should have seen it because it was so clear and posted everywhere in a real visible way on your website and on your content. Number three, you want to track your content. So use tools like Google Alerts, Pixie, Pixsy, or social media monitoring to spot unauthorized use of your work online. And if you find unauthorized use, you have to go after it. You cannot allow it. You have to take action to protect your rights. And fourth, decide how you want to handle it. So sometimes a polite email is enough. In fact, I would say 80% of the time, that's all that's needed. Other times, you might need to file a DMCA takedown, a Digital Millennium Copyright Act takedown, which is something I've talked about in another video. And I am going to do a full video on that so you understand that in a bit more detail. And ideally, contact a copyright lawyer to help you enforce your rights. So what to do if you want to use somebody else's content. If you do want to use somebody else's content to, in your business, here's how you're going to do it safely. Number one, you're going to get permission or a license. That's always the best practice. And many creators are happy to grant permission if you ask. Now, you may have to pay for the rights, but if the content is something that really helps you, then you should be willing to pay for somebody else's work. You would want to get paid for your original work, right? So that's the way it should be. Secondly, use royalty-free or stock content from reputable sources, but read the license language carefully. So all of the royalty-free and stock content websites have a terms of use you need to read. And then also each individual asset may also have its own license. So you need to make sure that you read that carefully and make sure that it specifically permits commercial use. If it doesn't, don't use it for that purpose. And if it gives limits on how much use you can make with a commercial basis, you need to adhere to those rules, or you could face fines and a lawsuit in the future. Number three, you can create something transformative. So the way you do that is you would add your own commentary, you would add your own analysis of the original work, your own original spin on it. Don't just repost and reuse. You could also create a parody of it. And that is almost certainly going to be covered by fair use. But again, it's a four-factor analysis. And if you've got a commercial intent, you have to be careful and you have to make sure that it's a true parody, because ultimately what the courts are going to be looking for is, would people believe that that original work and that original copyright owner was associated with that parody work or the work that has commentary. So it has to be clear to consumers that there's two different creators. And then finally, still credit appropriately. So when I say credit doesn't give you permission, it doesn't mean you shouldn't credit. You absolutely should. So even when you have permission, make sure you give credit. It may be legally required under the licensing language, so you need to read that and see what is required. And in fact, even if you're using open source, for example, that gives everybody the ability to use whatever that, foundational original content is, even open source licenses have limitations and they have, requirement to give credit. And so you need to make sure that you understand that and you abide by the terms of those licenses. And in any case, give credit to maintain goodwill and transparency, both with that original copyright owner and your followers. Doing it right protects not only your legal position, but your brand's reputation and integrity for professionalism. So obviously, fair use can be confusing, and even lawyers debate it. It's never a slam dunk clear case ever. But for founders and business owners, the rule of thumb is simple. If you're using someone else's creative work to promote your business, you probably need permission. And if you're creating original work, you need to make sure it's registered and protected so that you don't get taken advantage of. That's where I come in. Schedule a call with me and I'll help you understand what's protected, what's at risk, and how to keep your content strategy legally solid. You've worked hard to create your content and your business. Let's make sure it's protected and that you're using other people's work the right way.